Good afternoon, everybody, and thanks for joining us for another webinar in Conn Maciel Carey's 2016 webinar series. I'm delighted to present to you today a subject that crosses over the two practice areas at our law firm. Both the employment law and OSHA practice groups will be represented today in our discussion. And we're going to be talking about multi-employer, joint employer, independent contractor, and temporary worker employment law and OSHA issues, essentially all of those non-traditional employment relationships where employers and the Department of Labor's view of that relationship may differ. I'm delighted today to be joined by two of my colleagues, Jordan Schwartz and Lindsay Smith. Jordan is a partner in our labor employment practice, and Lindsay is an associate in both our employment and OSHA practices. And I'll let the two of them introduce themselves real quick, and then we'll talk about the subjects that we're going to cover, and then jump right in.
Thank you, Eric. As Eric mentioned, my name is Jordan Schwartz, and I'm a partner in the employment and labor practice here at Conn Maciel Carey. And essentially, we defend employers in all types of litigation, covering the breadth of both federal and state and local levels related to disability, equal pay, minimum wage and overtime under the FLSA, Title VII, FMLA, and really any statute you can throw a few letters next to, we represent. We also try to counsel our employers on compliance with these laws so that there is not the need for litigation. And hopefully through this presentation today, you all will get some guidance and advice on things that could help you avoid potential litigation in the future. In addition to that, we help with hiring, firing, terminations, and even internal investigations. And finally, we advise both unionized and non-unionized workplaces regarding employer and employee rights under the NLRA.
Good afternoon, everyone. My name is Lindsay Smith, and as Eric said, I'm an associate here at Conn Maciel Carey in both the employment practice and our OSHA workplace safety practice. So my main responsibilities in this position are to support Jordan and our other partners in our litigation efforts, as well as provide counsel to the employers that we work with, which includes reviewing and revising handbooks and other workplace policies. And then I also work with Eric and the other partners on our OSHA side to counsel employers in responding to OSHA enforcement actions, as well as providing counsel to our employers on the OSHA side.
And the last faceless voice that you'll hear today is me, Eric Conn. I'm one of the founding partners and the chair of Conn Maciel Carey's National OSHA Workplace Safety Practice Group. My practice focuses exclusively on all aspects of occupational safety and health law. I work with employers in inspections, investigations, enforcement actions, litigation, challenges to citations, involving the alphabet soup of agencies that get involved in workplace safety and health issues, primarily OSHA and the state OSH programs, the U.S. Chemical Safety and Hazard Investigation Board, MSHA, and the Environmental Protection Agency. I work with my clients and experts to manage investigations involving catastrophic industrial, construction, and manufacturing incidents, including explosions and chemical releases. I work with my clients to manage all aspects of OSHA litigation, including, unfortunately, an increased level lately of criminal matters, but as well run-of-the-mill citation appeals and negotiating settlements that will minimize the effect of OSHA enforcement actions on civil actions, wrongful death and personal injury actions, as well as the future operations of employers. I also conduct safety training, privileged safety audits, and a great deal of compliance counseling. So that's who we are. And what we're going to be talking about today is, as I said before, those unusual employment relationships where you've got perhaps a situation where you as the employer do not feel like a worker is your employee, but the Department of Labor may take a different view of that. So that's primarily going to be in the areas of the Department of Labor's new joint employer standard, where two employers perhaps are considered the employer to a single worker. Issues involving classification of independent contractors, whether that's done appropriately or a employee is misclassified as an independent contractor. Those are in the labor and employment context. And then on the OSHA side, we'll be talking about OSHA's temporary worker initiative that has moved into year 3 and what that means for employers who use staffing agency employees at their workforce. And then finally, the long-standing multi-employer worksite enforcement policy of OSHA, where we've got these other areas where we're talking about individuals who may actually be your employee. This is a scenario where OSHA can cite you even if they're not your employee under any of the measures, under any of the factors that we'll be talking about in some of these other tests. So I'm going to turn things over to Jordan right now to talk about the Department of Labor's new joint employment standard.
Thank you very much, Eric. So, joint employer. Let me just first spend a few minutes telling you what this actually means. We throw this word around a lot. So let's talk about what it means and then what are the implications arising from joint employment status. As many of you probably know and probably use, quite often, it just makes sense for you to use a staffing firm or a contractor to outsource some tasks. That can be a great way to fill gaps in your workforce without the hassle of hiring a full-time employee. But if you do that, which is the rightful employer of those outside workers? Is it the third-party firm? Or is it the company that hires them? Or is it both? Another way to think about this issue is when two or more associated companies employ the same staff person and they have control over the tasks and employment conditions of those workers, are both companies considered what is called a joint employer? That is the question we'll be discussing today. The reason this is such an important issue is that if you are considered a joint employer, you will have legal obligations to the shared employees, which could involve entering into a collective bargaining agreement or resolving disputes in a certain manner or strikes and work stoppages. It could also involve renegotiating any applicable contracts. So if you as the employer do not honor those obligations, and the fact is you might not even be aware of those obligations, nonetheless, you and your company could be fined in violation of a whole host of laws. The most well-known one in the joint employment context is the National Labor Relations Act, the NLRA, but other applicable laws are the Fair Labor Standards Act, Title VII of the Civil Rights Act, the Occupational Safety and Health Act that Eric and Lindsay will be discussing later, and possibly even state-specific employment laws. So as you can see, there's a lot of potential liability here, and it's really important that at least you understand this joint employment context. So importantly, in the last few years, both state and federal agencies have been broadening the joint employer relationship. About 2 years ago, the NLRB started developing a revised definition of joint employer in a CNN America case, in which they held that two entities will likely be considered joint employers when they share or co-determine those matters governing the essential terms and conditions of employment, and the putative joint employer meaningfully affects matters relating to the employment relationship, such as hiring, firing, discipline, supervision, and direction. So really what the NLRB did there was expand the definition to include a company's use of a contractor if that company exercised direct or indirect control over the essential terms and conditions of that contractor's employment. At the same time, California has also been expanding this definition. And in this way, California went from, in the past, where workers could only establish liability against the company by showing that an actual employment relationship existed both with the labor contractor that employed the temporary worker and with the company to which the worker was assigned to perform contracted services. In that context, it was usually by showing that the company to which the worker was assigned exercised significant direct control over the worker's terms and conditions of employment. But after January of 2015, this showing is now not necessary for numerous violations. Employers now may be deemed liable with the third-party contractor actually hiring and controlling the temporary workers, no matter the extent of actual control the company exerts over the temporary or contracted workers. For example, the employer can now be liable for issues related to payment of wages, even if they have no control over or participation in the payment of wages to a temporary worker hired by the contractor. And as many of you know, that is often the case. And you'll now see a corollary between what happened in California and now what's going on federally. Under the NLRA, the old standard was that entities were joint employers if they shared the ability to control or co-determine matters governing essential terms and conditions of employment, such as hiring, firing, discipline, wages, supervision, and direction. The control had to be actual, direct, and substantial. It could not simply be theoretical or possible. So the ultimate inquiry really was whether your company exerted significant and a direct degree of control over a worker. However, under exactly a year ago, the board issued a decision known as BFI, which is Browning Ferris Industries. Browning Ferris is a California-based recycling facility, and it used temporary workers from a company called LeadPoint. The employees at LeadPoint performed different tasks than BFI's regular employees and were supervised, hired, and fired by on-site LeadPoint management and LeadPoint HR representatives. However, because BFI subjected LeadPoint's hiring decisions to its own criteria and reserved the right to dismiss the temporary workers, the NLRB found that the two companies were actually joint employers. Thus, through this holding, they created this joint employer test whereby two employers are joint employers if, one, there is a common law employment relationship with the employees in question, and two, the putative joint employer possesses sufficient control over employees' essential terms and conditions of employment to permit meaningful bargaining. And while you think that sounds similar to the old language about the control over the employees' conditions and terms of employment, the difference here is this quote that comes from the BFI case. It says, "We will no longer require that a joint employer not only possess the authority to control employees' terms and conditions of employment, but also exercise that authority. So, reserved authority to control any conditions of employment, even if that authority is not exercised, is clearly relevant to the joint employment inquiry." It goes on to say, "Nor will we require that to be relevant to the joint employer inquiry, a statutory employer's control must be exercised directly and immediately. If otherwise sufficient, control exercised indirectly, such as through an intermediary, may establish joint employer status. So this slide really tries to summarize Brown and Ferris, what we say, in a nutshell. Under this new joint employer test, an entity can be deemed a joint employer even if it does not actually exercise any control over the employee's terms and conditions of employment, but perhaps based on a contract or otherwise, theoretically at some point could exercise control. Or it does not exercise any control, but rather exercises control through a third party. So by, for example, telling a manager in the third party that you are not happy with that employee and that the third party should potentially discipline or terminate that employee. That alone could deem you to be a joint employer. So this new standard really should cause every employer on this webinar to review your contracts and relationships with staffing companies and outsourcing partners, to identify and assess legal risks, and to take immediate action to mitigate or otherwise eliminate those risks. For outsourcing relationships, in order to avoid joint employment, you'll want to focus on ensuring that you don't interfere with the hiring and firing of the third party's employees. As long as the contractor doesn't violate any laws, it should not be a concern to you who they hire and fire. And with staffing firm workers, you want to be sure they have clearly delineated functions they'll be performing, as well as the length of the job, which should be relatively short and for a defined period of time. There's also a new decision that just came out, I believe, less than a month ago, called Miller and Anderson. And what Miller and Anderson does is it's concerned with the actual organization of employees. As most of you likely know, when a union seeks to organize employees at a particular organization, it must identify which classifications of employees will form an appropriate bargaining unit. Typically, in the past, the NLRB has not allowed unions to force organizations into a bargaining unit that mixes direct employees with those temporary employees or other employees that could be considered to be joint employees. However, the Miller and Anderson, what it held is that temporary employees now may form a bargaining unit with regular employees, even if there is not employer approval, if they share a community of interest. This really bolsters and takes off of the Brown v. Ferris holding by making it easier for temporary employees to unionize. An easy way to look at it is that Brown and Ferris has made it easier for a company to be considered a joint employer, and now through Miller and Anderson, it's easier to unionize once that joint employment relationship has been established. Real quickly, before I turn it over to Lindsay to talk about independent contractors, I just wanted to mention joint employment under the Fair Labor Standards Act, which is very related to what Lindsay's going to be discussing. In January of 2016, the DOL issued a memo supporting an economic realities test for determining joint employer status under the FLSA. And what the test does is it examines whether, like an independent contractor, whether a worker is economically dependent on the purported employer. It is not concerned only with control. So what it is concerned with under this economic realities test is, in addition to the direct and control of the work performed, it's concerned with the power to hire and fire, the determination of the rate of pay, whether a relationship is permanent or if it's just temporary, the repetitive and rote nature of the work, and whether the work is integral to the business. All that will help you decide under the FLSA whether or not it's a joint employment relationship. And finally, under Title VII, to determine whether a relationship is a joint employment, courts assess whether two entities utilize some form of control. And it considers a variety of similar factors, including the authority to hire and fire, control over payments records, such as payroll, and also the day-to-day supervision of employees. With that, I'm going to turn it over to Lindsay to start discussing the misclassification of independent contractors.
All right, thank you, Jordan. So like Jordan said, I'm going to spend just a little bit of time now reviewing how independent contractor status is determined, and then at the end kind of giving you some recommendations to try to avoid any sort of misclassification action or allegations. So as you all probably know, the Fair Labor Standards Act sets out multiple employer obligations to employees as well as multiple rights for employees. So for instance, and probably most significantly, the FLSA, Fair Labor Standards Act, or FLSA, requires employers to pay employees at least the federal minimum wage as well as overtime for all hours worked in excess of 40 hours per week. However, there are some exceptions to these obligations, and one of those exceptions is independent contractor status. Although classifying a worker as an independent contractor can be very beneficial for an employer, workers are often misclassified as independent contractors, which can actually be quite problematic. If a worker is wrongly classified as an independent contractor, he or she could claim significant lost wages because of these obligations under the Fair Labor Standards Act, such as overtime, as well as other damages. Such a claim, particularly when there is more than one worker that may be affected, that might have been misclassified, has the potential to be quite costly for an employer. And this is really significant because the Department of Labor has a focus on addressing misclassification of independent contractors. And this is most obviously seen through its misclassification initiative. Under this initiative, the Department of Labor and the IRS work together and share information to investigate and reduce the incidence of misclassification of employees as independent contractors. So the independent contractor status and classification is something that they're going to be looking very closely at, both the Department of Labor and the IRS. Moreover, 32 state agencies have also signed memorandums of understanding with the Department of Labor in this same effort. These agreements call for these state agencies to share information regarding independent contractor misclassification with the Department of Labor to establish a larger, more significant enforcement effort nationwide. The states that have made these agreements will likely also be allocated around $10 million in funding to improve their own misclassification detection efforts as well as their enforcement efforts pursuant to the budget for fiscal year 2017. And this has actually been similar in prior years. It's been around $10 million for this effort. The funding is specifically earmarked for various initiatives at the state level, including enhanced audit programs as well as employer education efforts. And I just noticed that I'm a little bit behind on my slides, so I apologize for that. Getting back to it, in total, President Obama's budget for fiscal year 2017 provides almost $277 million to the wage and hour division of the Department of Labor for these enforcement activities. And this includes cracking down on employee misclassification as independent contractors. The Department of Labor has also committed to conducting targeted wage and hour investigations in industries that have the most substantial independent contractor abuses. And then finally, as Jordan mentioned, the Department of Labor also recently published a memo emphasizing the broad definition of employee and employee, and based on that, it made a clear statement in that memo that it considers most workers to actually be employees. So because of the DOL's focus on misclassification and its effort to curb these types of misclassifications, it's very important to understand the factors that are used in assessing whether a worker is an independent contractor or an employee. And there are several different tests that have actually been put out there. The IRS has a test that it used. The Supreme Court has, developed a specific test that it considers, and there are even tests at the state law level. But the factors considered in each of these different assessments are basically the same. They're very similar. The wage and hour division's goal, as Jordan kind of explained a little bit before, is to determine whether the worker is economically dependent on the employer. If the worker is economically dependent on the employer, then he or she should be classified as an employee and not an independent contractor. One important factor considered in this analysis is the level of control that an employer exerts, as well as multiple other factors that I'm going to discuss at this next slide. So these particular factors have been identified by the Department of Labor, who will be, leading this enforcement effort, as those generally considered in determining whether an employment relationship exists under the Fair Labor Standards Act. So the first factor we have here is the employer's nature and degree of control over a worker. This factor addresses who sets the pay amount and the work hours, who determines how the work will be performed, whether the worker is free to work for other employers at the same time. An independent contractor must control the meaningful aspects of the work relationship with that particular employer. And generally, if an employer dictates how and when the work should be performed, the worker is more likely to be classified as an employee. The second factor we have is the extent of work performed and whether it's integral to the employer's business. If the work performed by a worker is integral to the employer's business, then the worker is more likely to be economically dependent on the employer and not really in business for himself. For example, if the employer is a large retailer, a worker who sells the retailer's product is more likely to be considered an employee, whereas a worker hired to repaint the inside of the facility or do some rewiring of the lights and different responsibilities like that, those workers are more likely to be considered independent contractors because their work, although very important to the facility being able to function, is not actually integral to the employer's specific business. Third, we have permanency of the employment relationship. A short, defined relationship suggests independent contractor status, while a permanent or indefinite employment relationship is more likely to suggest that the worker is actually an employee. Next, the worker's investment in equipment and facilities. An independent contractor should have a business investment in the work and equipment used to perform the task so that he or she shares in the loss of risk with the employer. Providing his own equipment to perform the work would support an independent contractor status, but does not necessarily prove that the worker is actually an independent contractor. For instance, if an employer reimburses the worker for the purchase of equipment necessary to complete a task, this is more likely to support an employee status. So then next is the worker's opportunities for profit and loss. This factor specifically focuses on whether the worker exercises managerial skills and or independent initiative and judgment on the job that would affect them in a way that they would have opportunity for both profit and potentially loss. If a worker can earn a profit by working more efficiently or suffer a financial loss due to inefficiency, then he or she is more likely to be considered an independent contractor. And finally, we have the level of skill, initiative, and independent judgment. If a worker's skills demonstrate that he or she exercises independent business judgment, and that particular worker takes initiative to operate an independent business in a competitive market, he or she is more likely to be classified as an independent contractor. Employers should not have to provide the skill training necessary for an independent contractor to perform the work that the employer has hired them to do. Now, all of these factors are going to be considered in determining independent contractor status. No one is more significant than the other, and they'll all be considered together to make that determination. So lastly here we have some recommendations for compliance and to avoid the potential to have a misclassification issue on your hands. the first thing we have here is that you should memorialize the terms and condition of an independent contractor relationship in a contract. Now, courts have found an employment relationship despite the parties' execution of an independent contractor agreement, but independent contractor agreements are still helpful in this effort. They should be signed by both the organization and the independent contractor, and the contract should also include specific acknowledgement that the independent contractor is not an employee. Second, we recommend establishing policies to limit direct control over the work of independent contractors. Now, it's important for this particular aspect that management employees of the company do not provide direct control over the work of independent contractors. And to ensure that happens, the employer should also provide training to these managers that specifically lets them know where the independent contractors are concerned, we're not exerting direct control. Third, establish fixed limited duration of the employment relationship, which is kind of what I talked about in the last slide. That is one of the factors that's considered. So you want to just make sure that if you do have an independent contract relationship, that it's for a fixed duration, and that fixed duration could actually be memorialized in the independent contractor's contract. Next, we have limit interaction between employees and independent contractors. Interaction between employees and independent contractors should be minimized. Some examples, provide separate trainings for both groups, separate communications, and exclusions from, particular social events. An independent contractor should also not be provided an employee handbook or other employee-specific policies. Finally, you want to review policies to make sure they do not cover independent contractors. The company should review vacation, sick leave, and other paid leave policies to make sure that they don't include independent contractors. And any other benefit plan should explicitly exclude independent contractors and just be used for the particular organization's employees. So now I am going to turn it over to Eric to talk about temporary workers.
Before we get to Eric, I just want to address a few questions that we're getting here. One question is whether, back to the joint employment issue, whether requiring a certain level of background checks for the third-party staffing would be an issue. And that's coming really close. As a prudent employer, you may want to require that the third-party staffing utilize background checks. And hopefully they already do that. But anything more, in terms of what exactly you require and the fact that they and a certain employee may not be hired because of something that you require, that would really lead the board to likely consider you to be a joint employer. A few other questions. We have an independent contractor question here about if a painter purchases paint and brushes and then we reimburse him for that. I don't love that if you're trying to maintain that he's an independent contractor. I mean, it's conceivable, possibly, but more likely than not, an independent contractor is supposed to bring his own tools, take his paintbrush from one company to the next company to wherever else, to the person's house. So if you're reimbursing him for that, it really is starting to look like an employment relationship.
What about vice versa? If you purchase it for him, but he reimburses you?
Oh, and in that case, if for whatever logistical reason he can't bring it to your place of employment, but he reimburses you for the materials, then it's akin to him bringing his own materials, and that leads much more to independent contractor status. Similarly, an independent contractor covered under your workers' comp policy seems to be something that's typically that you do with employees. And, while there might be some reasons that you want to do that, if your goal is to make sure that they're independent contractors, that probably wouldn't be what you want to do. I think with that, we should probably turn it over to Eric to get to the OSHA portion.
All right. Well, OSHA did not want to be left out of all this fun that the Department of Labor was having, pulling in responsibilities to a host employer for workers that might not traditionally fit the mold of an employee of that host employer. And in doing so, they launched a temporary worker initiative. Whereas Jordan and Lindsay talked about all sorts of different relationships, independent contractors, temporary workers, and other relationships, OSHA has focused primarily on just that one staffing agency temporary worker arrangement. And why are they focused on that? These are OSHA's general concerns about the use of temporary workers. What they are seeing, at least anecdotally, or hearing from unions or hearing from other constituents, are that employers are using temporary workers to skirt OSHA obligations. In other words, it's not my employee, it's somebody else's job to meet the training requirements and to meet the fit testing and medical examination requirements and other duties that might exist under the OSHA Act or its standards. Let's hire a staffing agency and have them do all that work so we don't have to do it. That's OSHA's view of why employers are using temporary workers. Others concerns that they have are that employers are using staffing agencies and using temporary workers to do the most hazardous jobs or to do the dirtiest jobs at the workplace so that they don't have to ask their own employees, their permanent employees, to do that work. And that raises concern for OSHA because you're bringing in the least trained, the least familiar with your workplace, your work practices. You're bringing in those people to do the most dangerous jobs, and that raises concern with OSHA. OSHA is also concerned about the use of temporary workers because they think that these are more vulnerable employees, vulnerable both to workplace hazards and retaliation because it's a tenuous work relationship. It is easier to remove a temporary worker from your workplace than it is a permanent employee, so they are more vulnerable to retaliation if they raise safety and health concerns, and they are more vulnerable to injuries and incidents because they are least familiar with your workplace. So those are more concerns that OSHA has about the use of temporary workers. OSHA is also concerned that temporary workers are not given adequate safety training or explanation of their duties and explanation of the hazards they might encounter by host employers or the staffing agency for different reasons. The staffing agency, because OSHA believes the staffing agency can't provide that sufficient level of training or explanation because they're not as familiar with the host employer's work site, with the hazards present there, or the strategies, tools, or procedures that would minimize exposure to those hazards because they're not there full-time and they don't know as well as the host employer. And then on the flip side of that, OSHA is concerned that the host employer is not providing that level of training and explanation because OSHA believes that the host employer doesn't consider that worker to be their employee, and so they're just not providing it because they believe that that job belongs to someone else, the staffing agency in particular. OSHA is also concerned that temporary workers are experiencing a high rate of fatalities and serious injuries on day one, theoretically day one, but really just early on in their tenure at a new workplace because of this issue of inadequate training, lack of familiarity with the hazards and the measures that might prevent injury because of those hazards. I don't believe that there is data that supports this or supports the idea that it's happening at a higher rate for temporary workers than it does for newly hired permanent employees, but OSHA has heard enough anecdotal instances of this that they are focusing on it, putting out press releases about it, developing and launching and implementing this temporary worker initiative because of it. So it's one of the concerns they have, and it's one of the major driving factors behind this initiative. And the last real driver behind this initiative that I've seen is the perception, I think probably correctly so, that there will be an increase in the use of temporary workers to fill out employers' workforces because of the implementation of the Affordable Care Act and for other reasons, but primarily I think the Affordable Care Act, and I'll talk about in a little detail later why that is likely to drive a greater use of temporary workers. So OSHA is looking at this and saying We don't think temporary workers are getting the same level of training. They're not as familiar with the hazards. The staffing agency can't provide that familiarity. Host employers are not providing it because they think it's the staffing agency's job, and they're going to make up a greater level, greater percentage of the workforce. All of this is a formula for an increased level of injuries and exposure to hazards among this vulnerable workforce. That's OSHA's view. So in response to that view, in response to those concerns, they launched a temporary worker initiative. And they did this back in April of 2013. So we're now 3 years into this initiative, and we've learned a lot about what OSHA is doing as part of the initiative. But at its launch, these were the goals that the agency had in terms of what they were trying to accomplish with this initiative. The goals included, primarily to protect temporary workers from workplace hazards. Other sort of secondary goals were to ensure that staffing agencies and host employers understand their relative obligations under the OSHA Act and under OSHA standards for protecting temporary workers. Whose job is it? And how do you segregate or demarcate that it's the staffing agency's job to do X, it's the host employer's job to do Y, and that will ultimately drive goal number 1, protecting temporary workers from workplace hazards. And then the third goal, and to me this is very significant, was to learn. And this was OSHA's last goal of the initiative when it launched, was to learn information about hazards in workplaces that utilize temporary workers. Who is using temporary workers? What types of industries are using them at higher levels than other industries? And what are the unique hazards that temporary workers might face because of that unique employer-employee relationship? And I think this is very significant because generally OSHA does things like this. They study, they learn, they gather data about unique workplace issues, and then after they've learned enough about it, they launch something a little bit more than an initiative. They launch a national emphasis program or regional emphasis programs. So that's something that I would think that we may see in the next year or two, is after OSHA has studied this issue and developed data about what industries are using them more often than other industries, they may then launch a targeted inspection program. So right now there's still a fair amount of it. There's already a fair amount of enforcement in this area, but my expectation is we're going to see even more after OSHA learns where it's being used the most and facilitates sort of a more targeting enforcement program. So let's look out for that over the next year or two. So what are some of the steps that OSHA has taken in connection with this temporary worker initiative? The first, I think, was to inform, instruct, and train their compliance, safety, and health officers for things that they should do in every inspection. Regardless of whether OSHA is there under an emphasis program on another topic, or they're there on an employee complaint, or they're there on an incident, in every inspection, compliance officers are supposed to look for and be able to answer the following questions so that they can determine whether they should expand the scope of the inspection, and also to learn that information that they're going to use to further focus enforcement resources and temporary workers. And that is identify, A, are there any temporary employees, temporary workers from a staffing agency present at this workplace? Are those workers exposed to either unique hazards or just the general hazards of the workplace? And if they are they provided training? And who is providing that training? And is the training adequate? Is it in a language that they can understand? Because OSHA's perception and anecdotal view is that often temporary workers, again, these more vulnerable workers, maybe are not English speaking, and so are they receiving training in a language they can understand, or are they receiving training at all? They're supposed to, compliance officers are looking at these issues regardless of whether it's related to an incident in any inspection. And then they're also required to gather information about the staffing agency. Where is it located? What is the supervisory structure of the staffing agency and the host employer vis-a-vis these temporary workers? And then determine whether, and this is very important in the analysis here in the context of an OSHA inspection, is determine whether the temporary worker is really an employee of the host, regardless of the label that the employer has put on this temporary worker, regardless of the contractual relationship with the staffing agency. Is the temporary worker really a host, an employee of the host? And here is the test that OSHA and the OSH Review Commission have been applying to that analysis. And this should sound awfully familiar, because I was hearing, as Jordan and Lindsay were talking about the various analyses for independent contractor versus employee or joint employer relationship, a lot of the same factors are being considered by OSHA and the OSH Review Commission to determine whether a host employer is really the de facto employer of a worker that's supplied through a staffing agency. And at a high level, the primary question is, does the host employer have the right to control the manner and means by which work is accomplished? And then underneath that umbrella question are these variety of factors. And again, just as in the analysis that Jordan and Lindsay talked about, this is not a, if you meet one of these criteria, you are the employer. You must meet all of these criteria to be the employer. It's a balancing act, and it's a litany of factors that the Review Commission will look at and analyze to determine whether, in total, on balance, do these factors weigh more in the favor of this worker being an employee or really being a contractor or an employee of the staffing agency. And the factors they consider are skills required. The more detailed the skill, the more specialty the skill is, the less likely they will be considered your employer. You brought in a specialist from outside to provide some specialty work for you. That is likely to be viewed as someone else's employer, the staffing agency or the contractor's employer, not your own. The location of the work, the more the work is present and really necessary to be done in your workplace, the more likely that person is to be considered your employee. The duration of the relationship, the longer that person is staffed at your facility and working for you, the more likely they are to be considered your employee as opposed to an independent contractor or the employee of some staffing agency. The method of payment, source of instrumentalities and tools, really important there, is who's providing the tools for the work to be done. I know we talked about that. One of the questions that was asked, the more you are providing the tools, the more likely you are to be considered the employer. Whether the host has the right to assign additional projects, as opposed to coming in on a contract to provide a specific task, if while that temporary worker is present, you can direct them to pick up a bunch of different projects or other unique projects that may not have been contemplated by the contract or spelled out in the contract, the more likely that OSHA and the Review Commission will consider that worker to be your employee. The extent of the worker's discretion over when and how long to work, setting their own hours versus you setting their hours. The worker's role in hiring and paying assistants, whether the work is part of the regular business of the host. That's a big one. Is the temporary employee there to do some special task, or is it really just driving the overall project or the overall business, the common business of the host employer? The more it is part of your core business, the more likely they're to be considered your employee. Is the employer providing employee benefits? Is it welcoming the temporary worker at their holiday parties? All of those sort of things factor into, are you treating them like your own employee or treating them like an independent contractor or someone else's employer? That will be factored into the determination. How they're compensated and tax treatment, also part of that analysis. The Marquis Case, the seminal case decided by the Review Commission on this issue, was the Froedtert Memorial Lutheran Hospital case, where the hospital was bringing in temporary staffing agency workers to supplement their workforce at the hospital. The hospital was treating them as not their own employees and not running them through the traditional training program and things like that, but the Review Commission determined that these were the hospital's employees, even though there was a contract that said otherwise, and the employer believed that they were someone else's workers, and even if the workers themselves believed that their employer was the staffing agency, the Review Commission said, on balance, looking at all those factors we talked about, we consider these workers to be the hospital's employees, looking at the hours, who sets the hours, when and how many, the duties they're to perform, the behavior of the supervisory folks involved in the process, who's providing immediate supervision and day-to-day supervision. the ability of the hospital to remove specific temporary workers from the premises, and then the big one, I think, in the analysis was that the hospital was providing scrubs, gloves, eye protection, all of the PPE that these workers were using. And these were primarily janitorial workers and some nursing and nursing assistants type of workers. The hospital was providing their PPE, the tools to perform the job, uniforms, and other equipment, and that was a major factor in the Review Commission determining that these were not someone else's employees, they were the hospital's employees. And the result of that was that the hospital was therefore responsible for the same safety and health obligations that the hospital has for their own regular permanent employees. And that's, the issue came up in the context of citations received by the hospital for not providing certain training, not providing certain types of PPE, and the hospital defended and said, hey, these aren't our employees, so these obligations aren't ours. The Review Commission said, well, we disagree. We do think they are your employees. I mentioned earlier why I think this is set to become a bigger issue for OSHA and for employers and for the workforce generally, and that's because we expect to see a rise in the use of temporary workers, at least in part because of the Affordable Care Act. The Affordable Care Act requires employers with 50 or more workers to provide health care benefits to employees who work at least 30 hours per week. This requirement promotes the use of part-time work and non-employee workers, independent contractors, and staffing agency workers to fill out your workforce. If you're close to that line, you might take steps to stay below that line so you don't kick into this category of having to provide health care benefits to your workers. And we know that this is not sort of a theoretical issue. We saw historically that when Massachusetts implemented Romney Care, that the use of temporary workers increased 6 times faster in Massachusetts than it did nationwide around that same period of time. So this is part of OSHA's concern for why they are focused on temporary workers. They think this is going to be a heavily used tool going forward. The long and short of it, the other thing, I talked about how OSHA was training their compliance officers to do certain things and to look for certain things during inspections. The other major component of OSHA's temporary worker initiative has been compliance assistance, educational materials that OSHA has produced and published on its website and talked about publicly to try and educate staffing agencies and host employers on what their responsibilities are vis-a-vis temporary workers. And the main thrust of almost every educational tool that OSHA has produced in this area is about joint responsibility. And this is David Michaels, the director of the agency, saying that host employers need to treat temporary workers just as they treat existing employees. And the real heart of this is that staffing agencies and host employers share control over the employee and are therefore jointly responsible for temporary employees' safety and health. It's essential, therefore, that both employers, the staffing agencies, and the host comply with all of the relevant OSHA requirements. And OSHA has produced these educational materials in a series of areas, including training, hazard communication, and record keeping. In the context of training, OSHA's view of temporary workers is that the responsibility depends on who exercises day-to-day supervision will determine which part of training is required. But remember that joint training requirement, OSHA views this as depending on who exercises the higher level of supervision will determine who's providing either general training or very specific site-specific or hazard-specific training at the workplace. And the general view, and it depends on, again, these factors of day-to-day supervision, but OSHA's general view is that the staffing agency will be required to provide general, high-level, basic training on safety and health topics. For example, what is hazard communication? Generally, what is an SDS? Generally, but at the end of the day, OSHA is going to expect host employers to provide site-specific training for employees. And the rationale is the host employer is in a much better position to provide that training because they know the hazards that are present at their workplace. They know what chemicals are being used or present at their workplace. They know the duties and tasks that the temporary worker is going to be assigned to do, so they're in a better position to provide that training. So that is generally OSHA's expectation in the context of training. And hazard communication, sort of a microcosm of that general view, that the staffing agency may provide generic hazard communication training, but the host employer is going to identify for employees the specific chemicals they may encounter, the PPE they should use, and how to implement the hazard communication program at that facility specifically. In the context of record keeping, we get a lot of questions on this. Do we have to record this injury? Do we have to call OSHA about this injury? Whose employee is this? And OSHA has long taken the position that regardless of who sends the paycheck to this individual worker, what really matters is who is providing day-to-day supervision of the worker's work activities. And if that's the host employer, and in most cases that's probably the case, unless the staffing agency has an on-site supervisory representative and gives the assignments and supervises and evaluates the work product that the temporary worker is producing, it is most likely that it's going to be the host employer providing that day-to-day supervision. And if that's the case, an injury that meets one of the record-keeping criteria to that temporary worker belongs on the host employer's logs. And one of the things that we encounter a lot is that it is hard for a host employer to ascertain whether an injury is recordable or the extent or the outcome of the injury because it's not their employee, and the person disappears and goes back to the staffing agency and maybe gets moved off to a different employer in the future. And since you're generally not providing workers' compensation benefits for those employees, all of those factors make it hard to gather information about whether an injury is recordable, how many days the employee was away from work or would have been away from work if they were returning to your workplace. But you have a duty as the host employer. If the injury goes on your log, you have a duty to make reasonable efforts to obtain that information. That might mean contact with the staffing agency. It might mean efforts to make contact with the injured worker. It might mean contacting the hospital or other clinic where care has been delivered to make your best effort to get that information. And it often means making estimates. We estimate that the number of days away would have been or should have been this for this type of injury based on our consultation with the healthcare provider because we don't know the actual answer and we're not able to get that information. In terms of reporting injuries, the advice I give to clients is if you do the analysis and that worker's injury belongs on your 300 log, then it's your duty to make the report to OSHA if it's a reportable case, a hospitalization, fatality, amputation, and so forth. In terms of record keeping, again, you should make sure you're avoiding duplication of record keeping. An employee's injury belongs on only one log and on one log only. And you make that determination with the staffing agency who is providing that day-to-day supervision. If it goes on your log, it shouldn't go on the staffing agency's log also. If it goes on the staffing agency's log, it shouldn't go on yours. The staffing agency and the employer should maintain good open communications to deal with those types of questions. You also, in the context of hazard communication and injury and illness record keeping, must establish a procedure for how you're going to communicate with another employer's employees in this context. Lindsay's going to talk about that in the multi-employer discussion, but the same carries true for a temporary worker. Make sure that you've established procedures and communicated procedures to the staffing agency and to the temporary worker about reporting injuries that they may suffer at your workplace so that you can evaluate, how did the injury occur and address the hazard, address the tool, the equipment, or the procedure, but also determine whether it's your duty to record the injury or perhaps you report it to OSHA. A quick list of best practices, and then I'll turn it over to Lindsay for the multi-employer worksite discussion. Even though the contract is not the end of the analysis and whether an employee, a worker is your employee or a staffing agency's employee, I think it's a start to the analysis. Therefore, I would pay a lot of attention to the contract language that you use to specify who is the employer, to specify who's responsible to day-to-day supervision, to specify who's responsible for OSHA-related duties. And that helps, in the analysis of whether it's your employee, but it also helps in actually implementing safety and health programs. You don't want to run into a situation where the host says, I thought you were doing this, staffing agency. The staffing agency says, I thought you were doing it. If it's clearly delineated in your contract, you avoid that falling through the cracks situation, and so that's a good way to address that. I think it's a good idea to conduct new hire, new project, a new visit to the work site training program for staffing agencies, even if you are going, to great lengths to make sure that they are still considered a staffing agency's employees. You should do a site orientation program, and I think it's a good idea to do that for any visitor to the site. So if you've got someone coming to do work at your site, you've done that as well. It might be your contractor safety program, a visitor safety program, but develop one of those programs and run any staffing agency worker through that program. In case OSHA considers it your duty to provide site-specific training, you've done it perhaps without creating a more likely scenario they're considered your employee. Maintain open communications. We've talked about that. Identify hazards and develop protective measures. If you are bringing on a staffing agency worker to do work that is not commonly done by your employees, do an assessment of that work. Do a job hazard analysis, because you know your workplace better, and you could provide really important feedback to the staffing agency and to that worker about hazards they might encounter and protective measures they ought to employ. Really, I think it's important to do an assessment based on these factors that we've been talking about all day as to whether OSHA is likely to treat this person as your own employee. Do that assessment, do that analysis before OSHA does it. And then just as a general rule, temporary workers or not, it's always a good idea to review your policies, procedures, training documents, and physical conditions at the workplace to determine whether you're in compliance. Doing audits is the best way to analyze all of that. We address a couple of questions real quick before I turn it over to Lindsay. Do we expect OSHA to consider construction subcontractors in the same way they view temporary workers? I think that's a slightly different analysis, and that's the analysis that Lindsay's probably going to talk about next on the multi-employer worksite enforcement policy. But many of the same factors apply, and you've heard sort of very similar lists of factors throughout the discussion today. The Department of Labor, in different contexts, to determine whether you are a de facto employer. I could see that same analysis on a multi-employer worksite, and even if you come short to de facto employer, if you're in a controlling position or those types of things that Lindsay's about to talk about, that analysis would determine whether you are responsible for citations, even if you're not the de facto employer. I'm going to turn it over to Lindsay and take a look at these questions and address some of them at the end, so I've had a chance to really look at what you're asking.
All right, thanks, Eric. So I will take us home in this presentation today with a brief overview of OSHA's multi-employer worksite enforcement policy. So we have much of this presentation discussing when certain types of workers may be considered employees and employer obligations if they are considered employees. However, OSHA's multi-employer worksite enforcement policy permits OSHA to hold certain types of employers liable for worker exposure to hazards even if the workers are not actually their employees. So as the description probably lets you know, a multi-employer worksite is one that has two or more employers working at the same location and working toward a common goal. In this context, if OSHA does come on to a multi-employer worksite and does an inspection and finds some hazardous conditions, there is a chance that more than one employer may be citable for those hazardous conditions. And in determining which employers it might cite and what obligations each employer actually has, OSHA will look at first the role of the particular employer. There's actually 4 categories that OSHA considers for this particular question, which I'll go over on the next few slides. And then also whether the employer met its obligations based on that particular role. So again, there are 4 different categories that OSHA lays out for employers on a multi-employer worksite. And you'll notice that each of the titles is pretty self-explanatory for what type of employer it is and the types of obligations that the employer might have. But I'm going to go through each and just kind of explain, what the employer may be citable for in each of these contexts. So a creating employer creates or causes a particular type of hazard. For example, an employer that damages a raised platform guardrail while hoisting a piece of scaffold would be considered a creating employer because it created the hazard that would be in place once that guardrail is damaged. It's OSHA's policy that employers must not create hazards, as I'm sure we are all well aware. And if they do, they are citable. And in this context, if the creating employer does cause a particular hazard to occur, they may be citable even if the employees exposed are those of another employer because they created the hazard. A creating employer will likely not be cited by OSHA if it takes reasonable and effective steps to keep employees away from the hazard that was created. The second category is an exposing employer. And an exposing employer is one whose employees are exposed to the particular hazardous condition. For example, going back to that guardrail situation, an exposing employer would be the employer of the employees working on the platform near the damaged guardrail and exposed to the hazard created by the damaged guardrail. An exposing employer may be cited if the employer had knowledge of the hazardous condition and did not do one of those three things provided on this slide, either act within its own authority to address the hazard. So that authority might be limited. An exposing employer doesn't necessarily have control over hazard correction on a work site, so it needs to at least act within the authority that it does have. Asking the creating or controlling employer to fix the hazard, or informing its employees of the hazard and taking steps to ensure that its employees are not exposed. In extreme cases, this could actually mean that the exposing employer would be required to remove its employees from the work site to avoid a citation if the controlling employer or the creating employer refuses to address the hazardous condition. The third category is called a correcting employer. And the correcting employer is the one responsible for correcting or addressing the hazardous conditions on a particular work site. For example, again, staying in with the guardrail situation, this may be the carpentry contractor that's hired to erect and maintain guardrails throughout the work site. And this person would be responsible to repair that damaged guardrail. The employer in this particular type of responsibility or role may be cited if it does not exercise reasonable care in finding and repairing hazardous conditions within its designated responsibilities. So again, in the context of the guardrail example, the correcting employer hired for the purpose of maintaining the guardrails would have a responsibility to take reasonable measures in detecting whether there is any hazardous condition created by a damaged guardrail. And then finally, the controlling employer is the one who has general supervisory authority over the work site. And this is often going to be the general contractor in these multi-employer work site contexts. This particular employer has the power to correct hazards or require others to correct the hazards. The extent of the measures that a controlling employer must implement to satisfy its duty of reasonable care is less than what is required of an employer with respect to protecting its own employees. But it still does have a responsibility to exercise reasonable care to prevent and detect hazards. For instance, it would not normally be required of the controlling employer to inspect hazards as frequently as it might be for employers in other roles. But the reasonable care asserted by a controlling employer will be evaluated based on multiple factors. And in its policy, OSHA states that it will look at the scale of the project, the nature and pace of the work being performed, and how the employer knows about how much the employer knows about the safety history and expertise of the other employers that it's hired. So there is a responsibility, if you're the controlling employer, if you're the general contractor, to take some measure to look into the history of those employers that you'll be hiring, to have an idea ahead of time of what sort of safety measures may be needed, what sort of safety evaluations may be needed. If the controlling employer knows its other employers have a history of non-compliance, then greater oversight would be expected by OSHA, and vice versa. If the controlling employer knows that those particular employers have a lot of expertise and a good safety history, then less oversight would be required by the controlling employer. So OSHA will evaluate the role of each employer based on its responsibility at the work site and the obligations that it has on the work site for the purpose it's been hired. Employers can be cited as multiple types. So an exposing employer could also be a creating employer. Maybe the same employer that caused damage to the guardrail also had its employees working right in that same location. And in that case, OSHA could cite the employer under either of these contexts. Under the policy that OSHA has established, compliance officers have been instructed to determine first whether an employer is an exposing employer, and then to evaluate the other potential categories under which this employer could fall. Eric already discussed this a bit in the context of the temporary worker initiative, but employers working together on a multi-employer site should have open communication and establish specific responsibilities based on each employer's specified role and what they were hired to do. So that, I think, concludes our presentation. We do have some questions, so we'll start reviewing those now and see if we can give you guys some responses.
Sure. There's a good question here in the analysis under the temporary worker situation, and actually I think probably applies in the multi-employer context as well, where it sounds like an employer has a manager on site from the staffing agency or from the contractor overviewing the completion of the job to document progress and other applicable material used and associated items. The subcontractor provides direction and on-site management for workers completing tasks and direction to perform work. Would this leave us liable for reporting ownership of the safety and health responsibilities of the sub? I would say that is one really important factor that might remove that responsibility. But again, the problem with this discussion that all of us had today is that there's no black and white test here. These are all factors that are part of a multi-factor balance. And the problem with that is that it's hard to give advice in this circumstance. I would say that is a very good setup. That type of arrangement is a very good setup to sort of push reporting responsibilities, record-keeping responsibilities, and perhaps all of the safety and health responsibilities back onto the contractor or the staffing agency, but without knowing the other factors like, are you providing the tools? Do you provide the PPE? Does the staffing agency or the contractor have access to information about the chemicals that may be on site to do their own assessment of hazards like that? All of those things would factor into whether it's more likely that you would take on certain safety and health responsibilities. But from a record-keeping and reporting standpoint, that sounds to me like one that would go back to the contractor because it sounds like they're supervising the day-to-day activities. I didn't hear in that description in the question about who's giving assignments, who controls, who does the specific assignments, but it sounded to me like that was going to be the contractor. So to me, that would be an example there where it goes back to the other employer. The multi-employer worksite doctrine is not enforceable in Texas, Mississippi, or Louisiana, according to the U.S. Fifth Circuit Court of Appeals. How might OSHA circumvent that limitation in those cases? That's an interesting point. I would say that OSHA very often ignores what the courts are doing. That doesn't mean that the review commission would ignore what the courts are doing, but I would still, maintain good work practices vis-a-vis the other employers on your work site, and do all the things that OSHA may recommend, just to avoid having to litigate back up to the Review Commission or back out to the Fifth Circuit to make sure you get the right result, because it's not unusual for OSHA to ignore the circuit courts, or to play dumb, or to actually be dumb. So something that you'll have to deal with. Best to avoid the citation than the hiring us to prove that you were right. But that's a great point. Let's see. We've got here's an interesting a point here. If you're a host employer and you request that a temporary employee not return to our work site, not requested that they be terminated, just that they don't come back to your workplace, would that still make us a joint employer? And, to me, that is, like I've said, one of the factors, thinking about it from the OSHA context, I know that is one of the factors, and a very important factor in determining whether you're going to be considered the de facto employer. I expect that the same analysis is true in the other parts of the Department of Labor doing this joint employer analysis. If you have the ability to remove someone from your work site, that is exercising a level of control. Really, even as Jordan mentioned earlier, whether you actually remove them or just retain the right to remove them, that would be enough to make you a joint employer, or at least be a major factor in the analysis to make you a joint employer in that context. So I think what we'll do here is provide you our contact information and encourage anybody whose question was not addressed today. I know we've kept you for a very long time. If you have any questions, or we didn't address one of your questions, or we totally missed the point of one of your questions, definitely send us an email or call us, and we're happy to talk about these things. I won't insult Jordan and Lindsay, but I can tell you I'm a huge nerd about this stuff. I love talking about it, so I'd love to hear from you after today. And as I mentioned, we are more than happy to share a copy of this presentation and our slides, and you will likely see an email from us in the next couple of days with that content. We encourage you also to join us for upcoming webinars. We do a monthly free webinar in the OSHA side of the house here, and our employment team does a lot of webinars in this area as well, so check out our website, and we'll include information about that when we circulate these slides. Also encourage you to check out our blogs. We've got the OSHA Defense Report blog and the Employer Defense Report blog. A lot of great content up there about issues like we talked about today and other breaking news in that context. Thanks again for joining us. This was a lot of fun, and we look forward to spending another afternoon with you soon, at least over the internet, talking about interesting OSHA and employment law issues. Thanks for joining us.